Shalom Rab. We are continuing with our analysis of the sources relating to the question about העברת נחלה. The question that we have posed is whether or not, assuming that one has available techniques that make possible leaving the estate to anyone that one wishes, even if not to Torah heirs, which in general would be the sons. The question that we must face before we utilize these techniques is to what extent it is permissible to divert one's estate from one's Torah heirs. We saw the Mishnah in Masechet Bava Batra that says that even if the techniques used are legally, halachically valid, and the will actually works to divert the estate to whoever one designates as one's heirs. The question is, to what extent is it permissible to do this, given that the Chazal expressed a great displeasure in taking advantage of legal techniques in order to divert the estate away from Torah heirs. The Mishnah seems to be stating a categoric statement that it is never permissible to divert from Torah heirs, and yet we've begun to see that there are exceptions, and the possible exceptions recognized by halacha depend on a number of criteria. And we began to discuss the first of those criteria, which is the identity of the alternative heirs. Who is it that you wish to provide for in your will that would not otherwise inherit under Torah law? Is there any difference whether or not it is widow, daughters, a first cousin, a charitable institution? To what extent is it permissible to divert the estate to any one or more of these alternative heirs? And we began to analyze this last time by looking at a number of criteria. According to those who are mekel, that allow for diversion of the estate in given circumstances, there are various criteria, various criteria. The first one is zehutam shel hiroshim alternativim. Who are the alternative heirs that you wish to benefit? And we saw the widow, we saw daughters, we saw sons, one son to the exclusion or to relatively large proportion of the estate. We've seen that those exceptions are possible. And I refer you back to the previous video to refresh our memory about those exceptions. What I'd like to look at right now is the question of tzedakah. To what extent is it permissible to leave a portion of one's estate to charity? This sounds like a question that need not be asked. Obviously, tzedakah is a very, very positive thing to do, and especially if one is accustomed to giving tzedakah during one's lifetime, it would only be natural to wish to do so in one's will as well. But let's consider the fact that by giving money from your estate or a share of your property from your estate to charity, you are in fact diverting those funds or those assets from your Torah heirs. And so the question of העברת נחלה would be relevant in such case as well. The question finds reference first and foremost in Gemara Masechet Ketubot. The Gemara talks about Mar Ukva, and the Gemara tells us as follows: Ki kanichai nafshe, when he was going to die, he felt that his days were numbered. Amar, he said to those surrounding him, Aiti li chushbanayu tzedakah, bring me my ledgers concerning the amount of tzedakah that I've given so far in my lifetime. Ashkach, and he found Daviktiv Bey, that what was written in his ledgers, Shivat Alfei Divrei Sianki, that he had given away 7,000 dinarim siankim, the form of currency. 7,000 was the sum that he found altogether. Amar, and this is what he said: Zavdaye klili, my baggage is light, urcha rechikta, and the way is long, as far. In other words, he felt that he had not given sufficient in his lifetime, and he was going to pass away, and he wished to bring a greater weight of schuyot, of mitzvot, of tzedakah to olam haemet. So then what did he do? after he found that he was unsatisfied with the amount of tzedakah that he had given so far, he went and gave away half of his total assets, 50%. The Gemara asks, how is it permissible to do this? Amar Rabbi Lai tells us that Ba'usha Hitkinu, there was a takanat chachamim in Usha. Amavaz Beis, Al Yivaz Beis Mechomesh, that if one wants to give away a significant amount of his assets to charity, he should nevertheless limit himself to not more than 1/5, to 20%. So how is it that Mar Ukva gave away 50%? Our answer is the takana relates to giving away money to tzedakah during one's lifetime, and the reason for the takana, not to give away more than 20%, is Shema Yered Min Chasav, because his fortunes may shift and he may lose all of his assets, and then he would become a charge upon society, and therefore, in order to create some cushion of security, Chazal were mitaken that one should not give away more than 20%. But if it's after death, if one leaves a will giving away 50%, as Mar Ukva did on his deathbed, then there's no concern of him possibly becoming a charge on society later on because he's going to die. Or if it was in a will, then he already has died, and therefore the rationale of the takana is no longer relevant. But take note of the fact that the Gemara doesn't ask, Hechi Avid Hachi, how did he do this if he's diverting his estate from his heirs? The Gemara doesn't ask that question. The Gemara just asks, how could he give away 50% if the general limit is only 20%? Siman, at least, from this Gemara, we may infer that giving money to tzedakah, in principle, involves no approbation from the Chazal, no words of Ruach Chachamim, Ein Ruach Chachamim Nochai Menu, because the purpose of giving tzedakah is equally as valid as leaving money to one's heirs. The Shulchan Aruch codifies this rule in Hilchot Tzedakah, Yoreh Deah. The Shulchan Aruch tells us as follows: Shiur netinata, how much should one generally give tzedakah during his lifetime? Im yado maseget, if he can afford it, yitain kfi tzarech haniyim, should give as much as the haniyim need. Im ein yado maseget kol kach, if he's not as lucky with the size of his estate, yitain ad chomesh nefasa, mitzvah min hamuvchar. Mitzvah min hamuvchar, it would be 20%, as we saw that being the maximum in Takonat Usha. That would be mitzvah min hamuvchar. Ve'achad min asara midah beinunit. A middle of the road method of measuring the amount of tzedakah that one should give would be 10%. Pachot mikan ayin ra. If you give less than 10%, you're being stingy. Those are the guidelines in general. Chomesh zeh shamru, when we talk about 1/5 of 20%, shana rishana me'akeret. It means when you begin to give away tzedakah, you can give up to 20% of your principal. Umikan ve'ilach chomesh erviach b'chol shana, only 20% of what you profit every year. Otherwise, if you keep giving away 20% of your principal every year, you would very quickly deplete all your assets, and that would defeat the purpose for which the takana was made in the first place. That is the Mechaber, the Shulchan Aruch. The Ramah adds as follows: Va'al yivazbez adam yoter mechomesh, shelo yitztarech labriot. One should not give away more than 20% in order not to become a charge on the rest of society. The dafka, now here's the point that is relevant to our discussion. The dafka kol yemei chayav. This limit of 20% only applies during one's lifetime. Aval b'shat moto, when one person is facing death, yachol adam litain tzedakah kol ma sheyirtzeh. Notice, kol ma sheyirtzeh. No limit at all. Gemara in Masech Ketubot tells us that Mar Ukva gave away, in fact, 50%. But the question is whether or not the Gemara told us that story in order to convey a message that is the maximum that one should give away, 50%. But the fact is that the Gemara doesn't say any such thing. The Gemara doesn't deal with any maximums b'shat moto. The Gemara just says that aval lachar mita let lamba. after death, we have no concern about his becoming a charge in society, and therefore the limit of 20% doesn't apply. So the Ramah tells us that if the limit doesn't apply, then whatever he wants. And the Ramah tells us that this rule appears in the Rif, the Rosh, the Ran, the Mordechai. Many Rishonim have adopted this position. On the other hand, we find poskim that are not willing to go that far. The Chachmat Adam, for example, in his halachot, in Halachic Tzedakah, tells us as follows: the rule that we've already seen, that one may not give away more than 20%, dafka b'chayav. Aval b'shat moto, yachol adam litain tzedakah kol ma sheyirtzeh. He quotes the Ramah, basically saying you can give as much as you want. But the Chachmat Adam adds on his own, when we kol makom, near Eli de'ein ra'ui litain mamono tzedakah u'laniach banav reikim im hein tzrichim leparnasah. One should consider the needs of one's family. And if any members of the family are needy for his financial support, then it would not be ra'ui, it would not be appropriate to give away everything to charity and to leave them with nothing. And he even quotes a very interesting statement in Choshen Mishpat. Choshen Mishpat Sof Simon Reish Nun Bet. It talks about the division of the estate. Talks about matanot mechayim. Talks about the issues relating to deathbed gifts, etc. And the Ramah there adds, "Sheomer lasot davar tov b'nechasav notnim liyoshim." If someone would say, in a very general statement, for example, in his will, that I hereby instruct my family, my heirs, my executors, to do with my estate the best possible that they can. The Ramah says that if, in fact, that is what one says, then one should give the estate to his Torah heirs, because that is the ultimate best alternative, because the Torah heirs obviously have a preferential status, being the heirs that the Torah designate. And if that's the case, says the Chachmas Adam, that is even to the exclusion of tzedakah. If one says, do the best possible with my estate, then you don't give any portion of the estate to tzedakah. You give it all to the Torah heirs. That being the case, the Chachmat Adam says we have to find the appropriate balance between tzedakah and mishpacha. If one explicitly wishes to give to tzedakah, then nevertheless one should take care of the family. Yachshav matzati, says the Chachmat Adam, b'sheiltot d'Rav Achad, sof parshat Ki Tisa. Aha dehama vazbez yoter michomesh. The rule that says that if one gives away his estate to tzedakah, or his money, not his estate, his money to, or his assets to tzedakah, he should limit himself to 20%. Hani mili mechayim, aval achar mita tilta. The Shilta says give away only 1/3. In other words, not even as much as Mar Ukva gave away. Mar Ukva gave away 50%. The Shilta say that if during lifetime, 20%. If it's not during death, at death, it should be 30%, 33%, a third. The story of Mar Ukva, itam hata, ita hatam, there we find Hani mili mechayim aval achar mita let lamba. The Gemara says that we have no concern about the amount one gives away to tzedakah. Mashma kedivrei Ramah, that there is no limit of 1/3. There's no limit of 1/2 either. There's no limit at all. Ella the Mar Ukva lo ratzah litain yoter mimachzit. There's the fact that the Gemara tells us that Mar Ukva gave away 50% is not intended to imply that there's a limit of 50%. The Gemara said let lamba. Well, if we're talking about deathbed gifts, then you can give tzedakah as much as you want. So therefore, it would seem that there's no basis for the version of this halacha that is brought in the Sheiltot that one is limited to 1/3. But nevertheless, for the Sheiltot, it would appear when the Gemara says we have no concern about the amount he's giving away. It means that you're not limited to the 20% of the Gzera, of the Takanasa. Avalo kulo doesn't mean that you can give away everything. What he's trying to say here is that it would appear that the Sheiltot had a different girsa, a different version in the Gemara. Our Gemara says he gave away 50%, and apparently, according to the Sheiltot, Mar Ukva only gave away 1/3, and therefore that became the alternative limit for giving tzedakah upon one's death. וכתב שם הגאון רב שי ברלין, אילו ראה רמה דברי השאילתות, ודאי היה כותב כן. If the Rama would have known what the Shiltot says, he would not have said that you can give away kol ma sherotzeh. He would have adopted a more limited approach of giving away a third and not more. So that's an interesting alternative to what we saw in the Rama itself. We said basically, here we find already that there's a concern for taking care of the family as well, and it may even be that according to the girsa of the sheiltot, that is explicitly fixed in the sugya of Masechet Ketubot that we saw concerning Marokko. The Aruch HaShulchan also relates to this question. He writes as follows: On the one hand, during one's lifetime, one should not give away more than 20% in order not to become a charge upon society. Only during one's lifetime. That is a quote from the Rama. If the Gemara brings us a story of Mar Ukva and tells us that he gave away 50%, it would seem to imply that that is the limit, and not 100%, as the Rama states. Havarat נחלה is inherently a problem. We've seen that all along in our lectures. And therefore, to the extent that one gives money to tzedakah, that is an exception to the general rule that one should not divert one's estate from one's Torah heirs. And therefore, when the Gemara tells us that Mar Ukva gave away 50%, we should take that as implicitly restricting us to 50% in order to leave the other 50% at least to one's Torah heirs. Very nice approach. He's saying, why 50%? Because giving tzedakah is basically doing good for yourself. It is to acquire more zchuyot as you are facing your aliyah limromim. And therefore 50% would seem to imply that you're taking 50% for yourself and 50% for the Yarshut. And how are you taking your 50% for yourself? By giving it to tzedakah. By giving it to tzedakah, you acquire the zchuyot that are inherent in that very important mitzvah. So now we've already seen a number of shitot. You see the Ramah says you can give as much as you want, even your entire estate. We saw in the Chokhmat Adam that at least the shiltot would say that you can only give 1/3. The Aruch HaShulchan says that we take the Gemara at face value, and if Mar Ukva only gave 50%, then that is the limit, 50%. So we have either 100% or 1/3 or 50%. There's an interesting tshuva, which is the last source I'll bring on this issue, tshuva of Rav Moshe Feinstein in Igrot Moshe, where the question is phrased explicitly. Is there a problem of diversion of the estate, inappropriate diversion of the estate, when one gives to tzedakah? And Rav Moshe says as follows: my humble opinion, Pashut, that when one gives money from his estate to tzedakah, vadai lo shayach le'asor. You can't say that it is usher to give to tzedakah. You can't say that giving to tzedakah constitutes העברת נחלה עבור יחסם. דכי עדיפה בניו מהו עצמו. Can we possibly state that his sons, his Torah heirs, are more important than he himself? Remember, the Aruch HaShulchan already told us that by giving tzedakah, one is basically benefiting oneself. And Ramosha follows in that line by saying, how could you say it's asur? Because you're benefiting yourself. We put aside the takanat usha. We talk about meikara dedina. It would be permissible during one's lifetime to give the vast majority of his estate, of his assets rather, to tzedakah. He has to leave something aside for himself. Why? Only because of a limud from the pasuk. The sug of charamim, where one is magdish his assets to the Beit HaMikdash, to Hegdesh, we learn from a pasuk in Masachet Erchin, Mikol Asher Lo, that if a person gives Chayra Mikol Asher Lo, then the Gemara darshans V'lo Kol Asher Lo. Mikol Asher Lo means that you're only giving a proportion and not all, but it doesn't state how much is the proportion, how much is all. So therefore, Ekronit, we could give away almost everything and just leave some behind in order to mekayim this pasuk. Rak mitakanat ushahi shal yivaz beis yoter mechomesh. And it's only as a result of that takana that one is limited to 20%. Kedam Rabbi Lai b'Ktuvot. There in the Gemara Masechet Ketubot and Daf Num, we are told about the takanat usha that a person should not be mivazbez yoter me chomesh. B'takana zu ahu rak mechayim shemi yered me nechasav. Moshe repeats that explanation. But the basis of the takana is in order that one should not become a charge on society. As we've seen in the story of Mar Ukva. If he leaves over some portion of his estate, everything else he can give away to tzedakah. Even in his entire estate. Even though he only said it very generally, he didn't mean to be matir, even to give away the entire estate. Since we already learned from Charamim, that pasuk, that limud mikol hashalo v'lo kol hashalo, would imply also b'shat mita, that one is not allowed to give away everything. Mashi satam, and the Ramo said kol mashi yotzeh, because it is not common that somebody should give away everything to tzedakah. It didn't mean to say everything he has, everything that he wants. To give away everything would be asur midoraita, based on that pasuk from Charamim. Interesting observation. Moshe says that this would seem to explain the common practice. People who have no children, they create some sort of a fund from which charity is supported. The Chatam Sofer says, how could they do such a thing, create such a Karen Kayemet? By doing so, they are disinheriting their heirs. Even if they have no children, they have Torah heirs. If one has no children, then brothers or parents or grandparents or uncles or cousins. The tree of heirs al pi Torah is broad. And the Ein L'cha Adam Yisrael She'en Lo Yorshim, Chazal tells us. So the Chatam Sofer asks, so how could you possibly allow to set up some sort of a trust fund like this, which diverts his entire estate from his Torah heirs? Utzrach Lomar, Yitam Dekivan De'en Lo Bein, that would justify, when one has no sons or children, that would justify taking this relatively extreme measure. Shamar Rabbi Yochanan Mishum Rashbi, the Gemara tells us in Masechet Bava Batra, Kol she'eino maniach bein li'yorshah kadosh baruch hu malei alav evra. It would seem to be that if a person has no children to inherit from him, that is a siman of kas lo aleinu mitzad kadosh baruch hu. V'tzarich la'atzil atzmo migeino u'b'tzedakah hu hatzala v'hu kodem la'atzmo mi'yorshav. So in such a case, then you are allowed to give preference to your own personal needs, to be matzil from onesh lamala. So therefore, you'd be allowed to set up a trust fund with your entire estate, even though your more distant Torah heirs are thereby disinherited. But Rav Moshe says, "Ein tzarich lazeh." We don't need that explanation of the Chatam Sofer. Even if he has children, and they are good children, no reason to disinherit them, etc. If you leave over some significant portion of the estate to your sons, then there is no problem with giving away the rest of tzedakah. We're going to see later on one of the criteria for allowing diversion of the estate is the question of how much do you leave behind for your Torah heirs. Here the Rav Moshe says that it has to be a davar chashuv. We'll see later on the Rav Moshe himself has various tshuvas in which he provides other guidelines for the amount of the estate that one should leave to one's Torah heirs, even if one is diverting the bulk of one's estate to others that are not Torah heirs. We'll just finish up with this last piece of the tshuva. שכיוון שזכות מצוות הצדקה תצילהו מעברת הקדוש ברוך הוא למי שאין לו בי. That the mitzvah tzedakah gives one a zechut to save him from the kas of Hakadosh Baruch Hu, which is reflected in the very fact that he has no children. That he therefore can allow preference to himself vis-a-vis his heirs. Then what about other reasons that one may be concerned for onesh? The fact that one has no children, according to Chatam Sofer, that would seem to justify one's being concerned that one needs more squiyot when he's going to Olam Hamet, and therefore he's allowed to get stuck. And the Rav Moshe says, and what if he does have children? There may not be other chataim that one is concerned about, in which one would like to be metaken before being olel adin. If you look at Shesh lo banim, Yesh lo lachush lo anshe shamayim achar mitato al eze chataim. Kari ein gadol Rabbi Yochanan ben Zakkai. Mi yamav ad yemot Mashiach. Rabbi Yochanan ben Zakkai was such a gadol. V'gam hu haya yarei mi anshe shamayim degenom. The Gemara tells us the story in Masechet Brachot. Rabbi Yochanan expressed his concern about being olel lamala and being omed ledin. V'nimtza shekol adam tzarich l'zchut tzedakah l'atzilo migehinom shehu kodem la'atzmo v'af mibanav. Why do we need that dafka, that chiluk of the Chatam Sofer, that only when somebody has no children, then one can be justified in setting up such a fund for tzedakah? So therefore, Moshe paskins that we can rely on a more liberal approach. I didn't see that piece in this tshuva. The dalet zuz was considered to be a significant enough amount to leave to one's yoshim. As I said, we'll discuss the amount that one should provide for Torah heirs in a future video. But af below Yerata Gehenom, now he goes one step further. Tam Sofer talked about when one has no children. But Moshe says even if you have children, but if you have other averot that you want to be mitaken, and therefore you want the skiyot tzedakah, it's also legitimate. But below you're at Shemayim, you're at Gehenom, sorry. Well, let's say the one has one's cheshbon nefesh, he's okay, and not concerned about being mitaken, any chataim. Nevertheless, im rotzeh lahosif zchuyot, nami hu tova gdola al atzmo, shekodem lebanav v'liyoshav, l'svar zu Chatam Sofer. One could wish to multiply one's zchuyot lamala, even if one is not doing it to be mitaken averot, but just to add zchuyot. Also okay. Bottom line, the giving of tzedakah on one's estate is, in principle, a diversion from one's Torah heirs. But nevertheless, we see a very, very liberal attitude towards giving away tzedakah. We saw Marukva gave away 50%. Rama says you could give away everything. We've seen the Chochmat Adam and Aruch HaShulchan that come along and say that it should be less than 100%. Rav Moshe says almost 100%, as long as you leave something significant to one's heirs. Bottom line, you can pretty much leave to tzedakah as much as you wish, as long as the Torah heirs are mentioned in some form, which we will see in later videos. Okay, that's it for now.